Hello dear students, my name is Sitaraman. Currently I am Vice Chancellor, local university. I would like to discuss in module 3 the issue of human rights and cultural diversity. I would present my argument broadly in two parts. The first part I would deal with the arguments that were known to be the cultural relativism versus universalism in human rights, and I will present my second part of argument under what I would call the re-emergence of cultural diversity in human rights. The two phases I consider metaphorically are distinct, and therefore the significance of making the two different kinds of arguments about culture in human rights. I would begin with the major approaches in the debate on cultural relativism and human rights. I will identify them as three. The first one I would like to say as simple universalism. This is the mainstream liberal thought that has seen human rights as the most acceptable form of imagining the rights question, and that must be universally applicable to all, and they are inalienable and they are indivisible. They are rooted in the idea of human dignity. Well, as all of us know, human dignity is a major concept that underlines all the discussions about human rights. The dignity is perceived as the most universal form in all human species. So therefore, for simple universalism, human rights are universal because they are species rights, they are rights of all human beings, and notwithstanding whatever kinds of cultural or other forms of differences that exist, rights should be equally applied. And that obviously is the main plank of the argument for simple universalism. The second approach I would like to present as retrospective constructionism. And retrospective constructionism, what I mean is a kind of an effort by scholars from diverse linguistic, cultural and social backgrounds try to represent that human rights values are not alien to their cultures or societies. They try to present a story where there is a long-standing presence of human rights values, and therefore their argument is to retrieve them now in contemporary representations. Their, of course, main methodological approach is to see human rights as a set of moral values. For instance, murder, not permitting murder, or right to life, the positive type of assertion, exists in all societies according to them. So in other words, all cultures respected life, all cultures have great respect for dignity, and therefore they need to be identified in terms of scriptural sources, in terms of other religious or philosophical sources that need to be documented and represented to ourselves. And that's the kind of an approach that we have seen in the retrospective constructionism. I would broadly identify three figures, but there are many people who have written about it, so it is indicative in terms of representation. The first one I will identify is the work of the Sudanese scholar Abdullahi Anaim, who worked on Islam and human rights for a long time, and who is well known for his very erudite renditions of why human rights is not inimical to Islamic way of thinking. So in other words, Islamic way of thinking, according to Anaim, accommodates as well as already encompassed many of the moral values that we represent today as human rights. In a very similar way, the renditions of Arvind Sharma, Hindu Narratives of Human Rights, and Stephen Angel's work, Human Rights and Chinese Thought, are other examples which I would like to use to say that the retrospective constructionism is a live process, and it is a continuous engagement of certain scholarship in thinking about human rights in ancient times of their respective societies. The third approach I would like to call as simple relativism, And what I mean by simple relativism can be exemplified by the statement of the American Anthropological Association sent in 1947 to the then Human Rights Commission, which was drafting the Universal Bill of Rights of Man and Citizens, as it was known at that particular point of time. The content of this short statement of American Anthropological Association basically said that there is no possibility of drafting a universal bill of human rights. And the contention is based upon three major presumptions. That is, that human being is a product of culture, number one. So in other words, culture is very significant in making a human person a human person. There is need to recognize cultural difference as individual differences, thought, action and so on is recognized. So in other words, there is a need for International Human Rights Commission to recognize there is something called cultural difference as well. Thirdly, there is no scientific method that permits us to understand the superiority of one culture over another. And in other words, all cultures have certain value systems. They could have difference between those value systems. And according to AAA, there is no possibility of objectively and methodologically demonstrating one culture's beliefs are superior to another culture's values and beliefs. And that's the third point, and hence the importance of cultural relativism. In other words, values are relative to its culture and therefore universal values are a myth. And this actually defined and set in motion a whole set of argumentations and conflicts between simple universalists and simple relativists for a long period of time, say I would say first 50 years between 1947 and 1999. The significance of 1999 is the American Anthropological Association issued a restatement on human rights, which we will come to in a moment. Let us now turn to the point of key debates in cultural relativism argumentation. In a way, cultural relativism arguments defined much of anthropology and human rights studies between 1950 and late 1990s. One way of understanding this conflict is to see as a tension between liberal individualism, which is the defining philosophy of modern human rights law, and communitarianism, which is what is seen as the cultural side of a community. So in other words, the collective sense, the we sense is seen as opposed to the I sense, and the I sense is represented by international human rights framework and the we sense is represented by a relativist argument. Well, there is in between a lot of reconciliation, and as I said, like the reconstructionists who try to present that need not always be seen as a dichotomous thing, but the relativism argument also continued. That's the fact of the matter in the debate. I would broadly present the anthropology's engagement with human rights began with understanding culture, and there are three broad ways of looking at culture and the way it is defined. The first is a very strong sense of looking of role of culture in making a human being a human person. In other words, the culture's role is constitutive. And if culture is constitutive, as the statement of American Anthropological Association in 1947 tried to say, then obviously the values of that individual would be relative to that culture. So that's the significance of it. So one assumption of culture was constitutive. The second kind of interpretation of culture is to see as instrumental. So in other words, culture is important, no doubt, but it is not so significant. It is merely an instrumental process by which human beings tries to acquire their sense of meaning making. That doesn't mean that culture is unchanging. That doesn't mean the values that we acquire are going to be with us unchanged through and through as we go. The third kind of cultural representation is multicultural or pluricultural or intercultural. I am using very loosely as interchangeable words, though there is a philosophical difference between the three types of terms that are used. For our conversation, they broadly represent the same meaning for the current purpose. The culture question played in cultural relativism debate as a way of cultural defense in some cases. The cultural defense question is a long and vexing problem. A number of international debates happened on this particular issue. To just give illustration of the kinds of issues that were debated on cultural defense question would be ranging from a very famous or infamous debate around female genital cutting. So in other words, in places like Sudan and other societies in Africa and maybe other parts of the world as well, where the women are taken to administer a genital cutting mechanism in the very early stages of their life, and it is seen as an important process of maintaining chastity, maintaining purity. There is also a religious kind of thing that is attached to, and so on. It is a major debate. Feminists felt it is obviously constraining to women's freedom, and of course the conservatives felt that is something that it is their religious matter, and so therefore that should not be questioned. In a very similar way, a number of other issues also come up under cultural defense. For instance, we are not very unfamiliar in South Asia to see what now came to be known as honor killings. That is, people who seem to be choosing their partners on their volition, but the families don't like it, and therefore either hunting them to kill or doing different things to violate their sense of individuality. And that obviously is a set of issues that came up, and it is often once again defended in the form of cultural defense. So in other words, there is a tension between community's understanding of how an individual should live and an individual's sense of freedom to define one's own self. And that obviously is one set of issues that repeatedly came. Of course, of late in India, we heard many cases of, for instance, Khap Panchayat and so on, which is also in a very similar sort of mold in terms of really looking at cultural defense question. The key point, however, is how should we react to these cultural questions? How should they be resolved? I would present the major debates, like for instance female genital cutting, are sometimes resolved through a technical process. For instance, health and hygiene, as the issues were seen as primarily questions of health and hygiene and presented to a larger community that the practice is a problematic one, and then of course there is a possibility of overcoming such kind of practices. But the philosophical question remains unresolved. Should the religious practice, if it is not having a question of hygiene or other kind of medical complication, be continued or not? And on that particular point, I would say a two-step process. Often we have seen, especially for instance you take the cases of honor killings, and in the case of honor killing, there is a criminal act, and the criminal act obviously has to be dealt as a criminal act, notwithstanding any other kind of defense. That is what the apex court in India has done in a recent case where a number of people who were authorized to kill, as well as those who authorized that killing, were convicted by the Honorable Supreme Court. And that aspect is at one level. But such kind of naming and shaming and such kind of punishment might serve as an exemplary deterring case. But we also know in the legal history that none of these kinds of practices have ever been deterred by legal punishment of any order, including capital punishment. So we need to understand that the criminal act has to be dealt as a criminal act, and that's it. But at the same time, we need to understand the deeper aspects of the social authority, as I already mentioned in the previous module. And I think the methodology, one possible way, as the feminists suggested, would be to look at transformative accommodation. And when I am saying accommodation, that doesn't mean you are condoning the practice, but rather you are trying to make a modification in such a way that the community is not feeling threatened, but at the same time there is a change that happens in an incremental way. How to mediate it, I suppose, is a very complex question and has to be dealt by case sort of a situation. The third point I would like to highlight in the debates on cultural relativism is the work of certain anthropologists, and I would here particularly name Alison Renton and her work on international human rights, universalism versus relativism. What Renton tried to articulate is a widespread belief, but her book summarizes the key points. Her argument about the issue is that the existing framework of international human rights law is not really a proper representation of all cultural values as universal values. They are and continue to be individual liberalism based, and therefore a variety of cultures would continuously find them as inappropriate for their own context. So Renton's methodology therefore is to take, number one, begin with the presumption that there are certain core values in most cultures, if not all cultures. So in other words, whether it is right to life or prohibition of murder, whatever way you would see, or questions of equality or liberty, or such other kinds of values, there is a possibility that most cultures would have some kind of recognition, and we must understand what is the most common minimum denominator that is possible as a consensus in those understandings of those values. That could be done, according to Renton, by doing or taking a massive empirical study of cultures. So in other words, there is a possibility of study and engaging with cultures in such a way that we will decipher the core values that exist in all these cultures. And according to her, that and only that should be the basis of determining what are the true universal human rights. So in other words, you will have some human rights, but they may not be universal because they need to be adapted, but there will be core human rights once the cultural consensus is arrived at, and that would be the universal human rights in a true sense of the term, according to Alison Renton. This she would call a particular phrase, this what she calls as cross-cultural universalism. So in other words, any universalism in this diverse world, according to Renton, has to be a cross-cultural universalism. Well, I think the moot question for many is there a feasibility of such kind of massive cultural study, number one, and number two, what if the core assumption is not really correct, that is, if there are some cultures who think differently than most universal values seem to be. What then would happen to this entire exercise of cross-cultural creation of universals would be an open-ended question, and Renton of course would refute by keeping the faith in place. So that's the third major kind of trend in looking at relativism debates. I would like to highlight my second part by suggesting that we have a re-emergence of cultural diversity in post-2000 context, which in my view is very different from the kind of debates that we have seen in the preceding 50 years. And what I mean can be exemplified by looking at three important legal documents that emerged from late 1990s to the early 2000s. I would begin with the Constitution of South Africa, which is of course in the cusp of 90s. The document recognizes the point of diversity as an important value in the construction of South Africa. In fact, the Constitution says we are united in diversity. That's the phrase the Constitution indicates about the South African nation. And I think given the fact of the background of South African context and apartheid, and the need to build a multicultural rainbow coalition, united in diversity, sounds very useful and very appropriate way of thinking about South African nationalism. Well, we in India and other South Asian countries also had a similar sort of phrase, and poet Rabindranath Tagore used this particular expression, unity in diversity, which is somewhat very similar, but in understanding that we are looking for a consensus while being very diverse in the subcontinent. I think is also an equally important way of representation, but there is a clear difference in the way the question of diversity is articulated by the South African Constitution at the end of this previous millennium. The second important document that articulates diversity differently is the UNESCO Convention on the Protection of Cultural Diversity and Expression, adopted in 2005, which first time recognizes diversity not only as a global value, but as something that is not in tension with the core human values like equality, like liberty of the individual. In other words, the convention is perceiving the importance of diversity as a foundation to enjoy values like equality, freedom, and so on. Right? That I think is also a significant shift. The third most important document I would like to talk about is the Declaration on Rights of Indigenous People. As I mentioned already, the declaration was in a draft form for over 30 years before the Human Rights Commission, and finally it got adopted in the General Assembly in 2007. The significance of the declaration, notwithstanding all the dilutions that it had to go through, is still a recognition that the indigenous communities have a unique way of life and a unique way of thought process. That means traditional knowledge, and that needs protection, respect, and equality status compared to the modern knowledge systems. So in other words, the declaration creates a new possibility of thinking about diversity in a very different way. In a way, I suppose this brings a modified version of a cultural difference question, not as a conflictual point, but as a point that needs harmonization in modern social context. The second important landmark that I would like to use to highlight this diversity being very different is the restatement of American Anthropological Association issued in 1999. You would remember the 1947 one highlighted a somewhat very simple, rigid, relativist frame where culture became a constitutive element, and culture is also an unchanging and static process of creating certain static values. The 1999 statement perceives culture as a dynamic process. So therefore, it is important to understand the definition that it is providing in the 1999 statement. I will read verbatim for the convenience of brevity. People and groups have a generic right to realize their capacity for culture and to produce, reproduce, and change the conditions and forms of their physical, personal, and social existence, so long as such activities do not diminish the same capacities of others. I think this recognizes culture as a dynamic concept, as a concept that continuously interacts, transforms, and changes into newer ways of thinking about any question. So I think that's already a great movement, and after this the statement further states that American Anthropological Association would look at all cultures in terms of how they fare vis-a-vis human rights, and it also says that it would like to refute any cultural defense in taking away human rights of individuals or collectives. And I think that's a major move from 1947 to 1999, and that once again defines diversity as an important question, but at the same time not to be seen as something that is in tension with human rights. So the final aspect I would like to conclude the debate on cultural relativism and cultural diversity issues in human rights is the following. There is most important point to recognize is that from a rather simple and judging way, we move to a rather asking questions and understanding way. So in other words, we are asking, do we know enough in order to judge? Yes, in that particular context, if an incident happens like an honor killing or like a cop diktat or like a matter like the female genital cutting or a child marriage, we can certainly see that as a violation within that context and law must take its course. But subsequently we also need to ask, do we need enough as to why child marriage persists notwithstanding legal prohibition? Why certain kinds of social authority resurfaces again and again in modern societies? Why female genital cutting or such practices anywhere in the world have legitimacy for a long time, right? That we need to understand, and that understanding is the only basis by which we will be able to try and transform those practices in a democratic way, without which we end up in being a coercive, confrontational mechanism which may not necessarily always be in the interest of human rights. So the point with judging to understanding is a new way of looking at transformatory politics, or the approaches that we need to bring to democratize social change in a way that they would, both in the long run as well as in a broader epistemic sense, damage the interests of human rights. So that finally brings me to say that the most important point in the second phase of the diversity question in international human rights lies very clearly in emphasizing the point that diversity, or cultural, human, linguistic, other forms of diversity, is actually a very complementary point to human rights as opposed to being in opposition to it. So therefore, the earlier liberal anxiety that diversity is opposing equality, or diversity would always mean justifying unfreedom, is a very wrong approach to take. There is need for rethinking about it. There will be social manifestations which require to be dealt in a legal way, and of course that's a given, but beyond that we must understand the cultural diversity is very necessary, is very much going to be there. That would mean that we will have universal values undoubtedly, but the meanings will be contextual. It is quite possible that dignity may be perceived in a particular society in a particular way, and it could mean different things in a different society. That doesn't mean, of course, one would justify any kind of practice as also a valid practice under dignity, but it is quite possible. I mean, I would not be able to give right examples at this point of time, but I can think of a case like in German society. Dwarf tossing was seen as a violation of human dignity. Well, dwarf tossing is tossing a dwarf for public entertainment. Neither the dwarf had problems nor the group had problems, but of course the state had problems. So the question to see is whether such practice is affecting human dignity. Well, I suppose if it were to happen in the subcontinent, people would not have even recognized about it. Well, of course, if it goes to a court, the courts will reflect, and of course we will see how those kind of questions will be redressed. And that brings me to the final point. The one possible way by which we should address the diversity question in human rights is to bring a cultural studies approach to human rights. In other words, as I was trying to say, that we will have universal values, but the meaning is always socially contextual. And that socially contextual thing emerges by studying the practices, the lived experiences of human rights in societies like India, where we could contribute in terms of expanding or enhancing or diversifying the understanding or the content or the meaning of a particular value, whether it is equality, whether it is freedom, whether it is dignity, and so on. For instance, I think one example that I think is equality is always seen in liberal context as equality before law. A movement like Sisters of Islam in Malaysia, in Egypt, tried to bring a point, what about equality before God? Or can women have a mosque of their own? Or can women have equality in prayer context, right? So in other words, it is important to recognize that there are multiple ways by which we should look at questions of equality and probably other concepts in terms of what makes equality equal. Whether it is a simple legal equality is the only way to look at equality question. There is a lot that universal human rights can learn and enhance their value by engaging different social and cultural contexts and bringing them into the fold of understanding human rights. I think that is in the benefit of really enriching a truly universal understanding of human rights. So therefore, culture is an important aspect, and it transformed into a great resource of enhancing universal human rights meaning as opposed to being a threat to it. Thank you.